Hello everyone, this is Diana Kim, Criminal Justice Librarian. In this video, I'm going to show you the components of a judicial opinion. What is a judicial opinion? Judicial opinions, also known as legal opinions, legal decisions, or cases, are written decisions authored by judges explaining how they resolved a particular legal dispute and explaining their reasoning. An opinion tells the story of the case, what the case is about, how the court is resolving the case, and why. What are the parts of a case? We will start with the preliminary stuff, and then we will get to the body of the opinion. First, the caption. The caption is the title of the case, such as Brown v. Board of Education or Miranda v. Arizona. In most cases, the caption reflects the last names of the two parties to the dispute, and it tells you who was involved in the case. If Mrs. Smith sues Mr. Jones, the case caption may be Smith v. Jones, or, depending on the court, Jones v. Smith. In a criminal case, the government brings the case, and the government itself is listed as a party. If the federal government charges Sam Jones with a crime, for example, the case caption would be United States v. Jones. Second, the case citation. Underneath the case name, you will find a legal citation that tells you the name of the court that decided the case, the law book in which the opinion was published, and also the year in which the court decided the case. In Graham v. Connor, shown here, the SCT refers to the Supreme Court reporter. Cases are published in books called reporters. The 109 refers to the volume number of the reporter, and the 1865 refers to the first page in the book that the opinion is printed on. Immediately under that, you see Supreme Court of the United States. That tells us that this case was decided by U.S. Supreme Court. Third, the author of the opinion. The next bit of information is the name of the judge who authored the opinion. In most cases, the opinion will simply state a last name followed by the initial J. In other cases, the judge's title is spelled out in more detail, as in this example, where we can see that this case was decided by Chief Justice Rehnquist. Okay, so enough of the preliminary stuff. Let's get to the body of the opinion. The body of any legal opinion consists of the facts of the case and the law. First, the facts. The first party of the body of the opinion is usually devoted to presenting the facts of the case. In other words, what happened? Surprisingly, there are no particular rules for what a judge must include in this section. Sometimes the fact sections are long, and other times they are short. Sometimes they are clear and accurate, and other times they are more vague. Typically, though, the facts tell you the judge's understanding of the case and what the judge thought was an important aspect of the case that helped the judge reach the decision. The facts of a case consist mostly of the events that occurred before the legal case was filed in court and that led to the filing of the case. Most opinions also include a section on the procedural history of the case. That is, what happened in the case after the case was filed in court. The procedural history usually consists of various motions, hearings, trials, and proceedings that went on in the case before the court that is writing the opinion was asked to resolve the disputed issue. Some opinions may make your life a bit difficult by calling the parties to a case by special legal names, such as appellant, appellee, petitioner, respondent, plaintiff, or defendant. It may help to keep in mind a few simple guidelines. First of all, when parties first appear in court, they are labeled using a pretty simple convention. In civil cases, where someone is bringing a lawsuit, the person bringing the lawsuit is known as the plaintiff, and the person sued is the defendant. In criminal cases, where a criminal charge is filed by the government, the person who has been charged is still known as the defendant. There are no plaintiffs in criminal cases, however. The cases are brought by the government, which is referred to as the state, the prosecution, or simply the government. Next, let's move on to the law of the case. After the opinion has presented the facts, it will then discuss the law. This section of the opinion describes the legal principles that the judge will use to decide the case and reach a particular outcome. In many cases, the law presented is done so in two stages. First, the opinion will discuss the general principles of law that are relevant to the case, given its facts, and next, the court will apply the law to the facts and reach the court's outcome. As you read the law section of the opinion, you should think about what source of law the court is using to resolve the dispute before it. Some cases interpret the Constitution, the founding charter of the government. Other cases interpret statutes, which is a fancy name for written laws passed by legislative bodies such as Congress. The law of cases therefore consists of two main parts, the holding of the court and the reasoning behind it. The holding is the method of reasoning that the court offers to justify its decision. For example, courts may justify their decision on grounds of public policy. The idea here is that the court believes that the legal rule it adopts is good because it will lead to a better result than any other rule. Courts may also justify their decision based on the court's understanding of the narrow function of the judiciary. When a case is governed by a statute, for example, courts may conclude that the result is required because that is what the legislature's statute says, no matter what the court thinks would be the best rule. Similarly, when past courts have already answered similar questions before, a court may conclude that it is required to reach a particular result because it is bound by the past precedent. Other courts will rely on morality, fairness, or notions of justice to justify their decisions. Many courts will mix and match, relying on several or even all of these justifications. Finally, we move on to the disposition. The disposition usually appears at the end of the main opinion and tells you what action the court is taking with the case. For example, an appeals court may affirm the lower court decision, upholding it, or it may reverse the decision, overturning it, and remand the case, sending it back to the lower court for further proceedings. For now, you should keep in mind that when a higher court affirms, it means that the lower court had it right. Words like reverse, remand, and vacate means that the higher court ruled that the lower court was incorrect. Now a bit about concurring and or dissenting opinions. Not all justices of the Supreme Court agree. Concurring and dissenting opinions are opinions by judges who did not entirely see eye to eye with the other judges of the court and wish to express a slightly or even dramatically different view of the case. In general, a concurring opinion is an opinion by a judge who would have reached the same result as the majority, but for a different reason. Dissenting opinions are opinions by judges who disagree with the majority's result entirely. In most cases, dissenting opinions try to persuade the reader that the majority's decision was simply incorrect. In the next video, we'll talk about how to read a case and what information to look for. If you have any questions about anything covered in this video, please feel free to reach out to me. You will find my contact information in Blackboard, as well as a link to schedule an appointment if you would like additional help. Thank you and have a great day.